Thanks for joining us for this archive of Teaching American History's Insights from History webinar from April 15th, 2020. The title of today's program was Fire in a Crowded Theater, Civil Liberties in Times of Emergency. We were joined again by Dr. Jeff Sikkenga, Professor of Political Science at Ashland University and Executive Director of the Ashbrook Center, and Dr. Joseph Fornieri of the Rochester Institute of Technology. And they discussed this connection between our individual liberties and how these are shaped, how these are understood, and in so many cases, how they have been abridged during times of emergency using a number of historical case studies. Thanks again for joining us.
I want to particularly welcome today our teachers who are joining us through Teaching American History. It's one of our teacher programs. It's a great project that we have for empowering teachers to go back to original historical documents and have conversations with their students about the enduring questions in American history. So I want to welcome folks who are coming to us through Teaching American History as well. This is, as many of you know, the fourth webinar in our series of 6, which we're calling Insights from History. Our first one, those of you here remember, was on the 1918 Spanish flu pandemic with Dr. Jennifer Keene from Chapman University. Wonderful conversation. Our second, 2 weeks ago, was on presidential leadership in times of crisis with Dr. Steve Knott of the Naval War College. He was also the Thomas and Mabel Guy Professor of American History and Government in Ashbrook's master's program. And last week, we had the great fun and privilege to be talking with Dr. Steve Hayward on the question of government's the economic effects of government's response to crisis. And today, as you know, we're tackling another really important topic, the question of civil liberties in times of emergency. And we really think of this webinar series and this topic itself as part of Ashbrook's mission. As you know, our mission is to strengthen constitutional self-government in America by educating our fellow Americans in the history and principles of the country. It's one of our fundamental beliefs at Ashbrook that we can learn from history, get a historical perspective on the current situations that we face, like our contemporary crisis, but also to renew our own understanding of America and of American principles. We really think of history, like the Greeks thought of it, as inquiry. We go to history, we go to the past, we ask it questions and listen for its answers. And that's really part of the Ashbrook way of teaching and learning. It's the way we think about education. We don't think of education simply as information or certainly as indoctrination. Not either one of those two. We think of it as discovering for yourself the truth through conversation with the past, through conversation with great minds, and through conversation with each other. We base our entire educational programs on the principle that we go all the way back to Aristotle. All people by nature desire to know, but then we add, but they don't want to be told. They want to discover for themselves. And so we want to conduct this webinar today in that spirit of conversation based on primary historical documents. Dr. Joe Fornieri, who's with us, has had us look at a number of Supreme Court cases, which give us a valuable insight, I think, into the ways in which these issues have been thought of in the past. And that conversation today will be a chance to bring history to life and talk with it. Our conversation, as you know, is entitled Fire in a Crowded Theater, Civil Liberties in Times of Emergency. A really fundamental question is, how do we understand the relationship between liberty and security in times of crisis? And to help us think through that is Dr. Joe Fornieri. Joe is a professor of political science at Rochester Institute of Technology. He's also a professor in Ashbrook's Master of Arts in American History and Government program. Joe teaches classes on American politics, constitutional rights and liberties. For us in our master's program, he's taught a class on the First Amendment, and he's also taught a class called Free Speech in War, Hate, and on Campus. Three interesting aspects there of speech. And I know we're going to get into that today. Joe has his bachelor's from State University of New York, his master's from Boston College, and his PhD from the Catholic University in Washington, D.C. He is a fine scholar, a serious thinker on these questions, who's written a number of books and articles, co-edited, edited many scholarly works. Just a few for that are particularly my favorites. There's so many to choose from, but a few that are my favorites. He has a wonderful book called Abraham Lincoln, Philosopher Statesman, which is a deep investigation of Abraham Lincoln, not just as a political actor, but also as a thinker. He has a wonderful book called The Language of Liberty, the political writings and speeches of Lincoln. And he is now finished or finishing a volume with Ashbrook on our core documents volumes entitled The First Amendment. So Joe has been thinking about constitutional liberties and about the place of those in American history for his entire scholarly career. And it's a privilege for us to have him with us. He's also, I know from talking with him and listening to him, he's a wonderful guitarist and musician. So we may not ask him to sing today, but we are going to ask him to get his thoughts. And I wanted to start, Joe, if you don't mind, with a kind of opening question to set the scene for us. One of our first readings is a Supreme Court case called Ex parte Milligan. And one of the great issues in a free society that's governed by a constitution is how to understand the relationship between liberty and security, especially in times of emergency. It's obviously an issue that we are facing today very profoundly in states across the country. And as we know, though, in American history, we've faced emergencies before, both in national security and in public health. So I wonder if we could start our conversation on the national security side and talk about national security emergencies and civil liberties. And probably the most severe example of that, as you know, was the Civil War, when Abraham Lincoln took some actions like suspending the writ of habeas corpus and establishing military commissions that caused controversy in his day and continue to be something that people think about and argue about and teach to their students. So I wonder if you could just start us off by taking us back to that time in American history, in the beginning of the Civil War in 1860. What's the situation of the country at that time? What did Lincoln do? And for those of us who aren't experts, could you tell us a little bit, as you're explaining, what is the writ of habeas corpus? And what were these military commissions?
Sure. Of course, war opens up challenges to the Constitution that are extraordinary and places perhaps some of the greatest pressures on the Constitution. The Constitution seeks to secure both liberty and order. Ordered liberty is the term used by the founders. And of course, when Lincoln was elected on November 6th with 39% of the vote. Shortly after, on December 20th, South Carolina seceded from the Union. By February 1st, 7 states had formed the Confederacy. And as we know, on April 12th, Fort Sumter was fired upon. This is before Lincoln is even inaugurated on March 4th, 1861. The timeline is interesting here. It's noteworthy. Today is, I don't know if we did this on purpose, but the 159th anniversary of what's known as the 80 days. And this is the 80 days from, roughly 80 days from April 15th, Lincoln's first call for troops. He called for 75,000 troops to suppress the rebellion, to convoking Congress in a special session on July 4th, the symbolic date, 1861. And that's where he provided a justification for the extraordinary measures that he would take in this interval from roughly April 15th to July 4th. Some wondered whether or not the Constitution would survive Lincoln's effort to save it. And some of the controversial actions taken during this time was suspending the writ, which I'll talk about in a moment, raising money without congressional authorization, blockading the southern ports without congressional authorization. Shortly after, he would establish military commissions and tribunals as well. During this time period, there was a controversial case that was decided none other by Roger B. Taney, who was riding the circuit. It was at that time Supreme Court justices rode the circuit, and this case was called Ex parte Merriman, and it involved a Marylander who had sabotaged bridges, cut telegraph lines to prevent Union forces from entering his state. Okay, keep in mind that Congress is out of session during this crisis. We look at the historical context. Interestingly enough, the governor of Maryland, Hicks, told Lincoln on April 19th not to send any troops through his state. After April 15th, on April 17th, Virginia seceded from the Union in response to Lincoln's call for troops. So the United States Capitol was encircled, and there was a very intense and strong insurgency in the border states. Remember, Maryland is a border slave state that was teetering on disunion. On April 19th, when Union soldiers did attempt to pass through Maryland, they were mobbed. Four Massachusetts soldiers were killed, 36 were wounded, and riots broke out. And then shortly afterwards, about 6 days after that, Merriman, who I mentioned was a Maryland citizen who was part of a cavalry group that destroyed bridges and cut telegraph wires, was arrested. Now, he wrote to Roger B. Taney, who was riding circuit at that time, asking Taney to provide a writ of habeas corpus. Again, we'll define that and explain that in a minute. When Taney issued it, the presiding officer at Fort McHenry, where Merriman was arrested, notified the official agent that the writ of habeas corpus had been suspended. Now, what is the writ of habeas corpus? Writ of habeas corpus is a due process guarantee going back to common law. In fact, there was even a very important law passed in Great Britain in 1679, known as the Habeas Corpus Act. It literally means you bring the body, habeas corpus, and its origin is derived from a judge ordering the jailer to bring the body of the accused or the detained before him, and to release the accused if there are insufficient grounds to hold him, or if the person is not given a trial and in a timely manner. So what it does is the writ of habeas corpus prevents against arbitrary arrests and indefinite detainment. That was the problem in Great Britain. The king would arrest people and they would rot in prison without ever having a trial, or they would never be informed of the charges against them. So in suspending the writ of habeas corpus, Lincoln is giving himself really a free hand and detaining any potential insurgents and denying them really of a trial, the opportunity to have a trial until further notice. Now, what's interesting is once the writ is suspended, there can be different forms of trying the accused. Okay, if that person eventually is tried after some point. And Lincoln did, during the time of the war, implement military commissions. And that was as we saw in the primary sources in Ex parte Milligan, that was declared unconstitutional where civil courts were operating at the same time. So to finish this up, Roger B. Taney of Dred Scott infamy declares Lincoln's suspension of the writ of habeas corpus unconstitutional. Now, the Constitution in Article 1 does allow for the suspension of the writ in times of rebellion or invasion. But of course, Article 1 has to do with the legislative power. So Taney interpreted the Constitution quite narrowly, that only Congress could suspend the writ. Lincoln at this time suspended the writ to create a corridor, okay, from Washington, D.C. to Maine, so troops could fortify and defend the Capitol without being disturbed, as occurred in the April 19th riot. And, remarkably, it's hard for us to think that the Capitol was completely vulnerable and unprotected, right? There was no standing army at the time. So Lincoln came under sharp criticism. He ignored Roger B. Taney's order, and again, it was a court decision from the circuit court bench, not the entire Supreme Court. And a few years later, in March 1863, Congress enacted the Habeas Corpus Act, which granted the president the power to suspend the writ. So Congress was involved in this. However, the Habeas Corpus Act of 1863, March 3rd, 1863, said that any civilians who were accused or detained should have their names written down and have the opportunity to be tried in a civilian court. And unfortunately, that was not complied with. There were roughly 13,000 civilians tried during the Civil War by these military commissions, in which we know that there are not the same safeguards. So this was a very controversial measure. Roger B. Taney was embittered, and Lincoln, in his July 4th message to Congress, 1861, provides the rationale for suspending the writ. It's a fascinating argument to juxtapose Lincoln's rationale and Taney's rationale in Ex parte Milligan. Notably, and then I'll stop here. Thank you, Jeff. Notably, and this often happens, and I expect it'll happen in these difficult times as well, the court defers to the president or the executive or Congress in a time of crisis, but afterwards restores fundamental civil liberties. And that's what occurred in this case after the Civil War, an Ex parte Milligan by a court Lincoln had primarily appointed.
Well, that's really helpful, laying the context and background. Can I ask, and questions, we're getting questions, of course, from our participants here, yeah. And they're asking sort of the same kind of question that's on my mind, because one of the things I note in the reading that you gave us, Ex parte Milligan, this case, is it does happen after the Civil War, so the crisis has passed. Yes. But one of the things the court says, and I'll just read it, is in the fourth paragraph that we have of our version. It says, "The Constitution of the United States is a law for rulers and people, equally in war and in peace, and covers with the shield of its protection all classes of men at all times and under all circumstances." So what the court seems to be saying there is, look, there's not a different constitution in an emergency and in peacetime. There's not a different constitution in war and in peace. It's the same constitution at all times, which means people's constitutional rights and liberties are the same at all times. So take us back to what you said before. Abraham Lincoln did not argue, as I understand it, that in an emergency, the president can act outside the Constitution. He was arguing that he was acting inside the Constitution that we have. Can you tell us a little bit more? And some people have asked, what was Lincoln's argument in favor of what he was doing? Not just that it was necessary, but also that the Constitution permitted him to do that. Because, as you know, in our system, and I think the teachers out there know this, and our friends and supporters know, one of the things Ashbrook stresses so much is the importance of our Constitution and the idea that government has the power that's given to it through our Constitution, whether that's the federal government, the U.S. Constitution, or the states and the state constitutions. They only have as much power as given to them by the Constitution. So what was Lincoln's constitutional argument that you mentioned for taking such extraordinary action in a time of emergency?
Thank you so much. Great question. Let me say, Jeff, the question you raise and that others raise in terms of being grounded in this text. The Constitution is a law for rulers and people equally in war and in peace. Lincoln agrees with this. And I think the distinction that Lincoln would make, and Lincoln did make, is that, yes, it is the same Constitution, but the Constitution itself distinguishes between the circumstances of war and the circumstances of peace. The very fact that the habeas corpus provision is included shows that the founders recognize that we cannot expect ordinary due process, to be served during extreme crises. So one can speak about the Constitution in wartime and in peacetime. And it's very interesting now because, we're liking this epidemic and this pandemic to a war, and we're speaking about fighting an invisible enemy, which would, certainly provides a pretext on the part of the authorities to claim more power in defeating the enemy. So Lincoln would argue that yes, it is the same Constitution, but the Constitution itself, and there's ample precedent, distinguishes between wartime and ordinary circumstances. His argument in the July 4th, 1861 argument is absolutely fascinating. He does this. Tawney and ex parte Merryman accuses him of dereliction of duty. It's very stinging in that circuit case, and claims him that the commander-in-chief is not fulfilling his duty in faithfully executing the laws by ignoring the judicial branch. What Lincoln does is he turns this back on Tawney. First, he acknowledges that Congress does have a role in suspending the writ of habeas corpus, that this cannot be done indefinitely and unilaterally by the president. I think those are two key terms, indefinitely and unilaterally. Of course, Lincoln does mention, he looks at the factual basis and notes that Congress was out of session. Now, he may have been able to summon Congress, the Constitution grants the president that power, but as we mentioned, there was no standing army to protect the Capitol, and there was a real concern that the Confederates would launch a preemptive strike, at the vulnerable Capitol, and even demoralize the country by preventing Congress from assembling. So he acknowledges Congress's role. He mentions the factual basis that Congress is out of session, Then he makes a hypothetical argument. Now, you mentioned, did Lincoln appeal to the Constitution in justifying these extraordinary measures, or did he invoke a power higher than the Constitution? Well, at times he used rhetoric that invoked what legal historians refer to as all the laws but one argument, and it comes from the July 4th message, where it's a response to Tawney, who says, you're not enforcing the law. And Lincoln says, well, if I was to not suspend the habeas corpus, none of the laws would have been none of it would have been followed. And so am I to adhere to all the laws, to follow all the laws except one? Okay, he argues. So inevitably, given the dilemma, laws were going to be broken. It was better that one law be broken to uphold the Constitution as a whole. So that's a response to Tawney's accusation that he was derelict of duty, that inevitably, given the necessity of the situation, a law would have been broken, and it was the lesser of two evils. It was the good of the people. Salus populi is another term legal scholars use. And that it resembles very much John Locke's argument of prerogative, that you act outside of the Constitution in extraordinary circumstances to protect it. But then after making this hypothetical argument, this is classic Lincoln, he concedes, he makes a hypothetical argument, and he says, but no law was broken. No law was broken because the Constitution itself distinguishes between peacetime and wartime, and that the Constitution includes the very provision that the writ of habeas corpus can be suspended in cases of rebellion or invasion, and this clearly is a rebellion. Now, he concedes that the suspension clause is included in Article 1, okay? But he says that is not decisive, right? That is not decisive in terms of justifying who has the authority to suspend the writ. There he disagrees with Tawney. And it's kind of a Hamiltonian broad construction. The very fact that the ends are specified by the Constitution for security in an extraordinary situation justifies the particular and reasonable means to that end. And of course, Lincoln emphasizes that Congress was out of session, so they could not suspend the writ.
Can I?
Yes.
That because argument. So what Lincoln is saying here is that he, as president, can act in this emergency, essentially using a power that's given to Congress by the Constitution, but not restricted only to Congress.
That's what he's saying. Yes.
Situation because Congress was not in session and couldn't meet.
Yes.
It was like this power was sitting there, not able to be used.
Yes. And he acknowledges that Congress has a role in this.
So, for example, Congress could come back and pass a law saying the writ of habeas corpus shall not be suspended. They could override the president, for example.
Yes.
Okay.
He says nothing has been done beyond the competence of Congress to ratify once it has reconvened.
Okay. So that's right. So he's not claiming, as you said, the power to suspend habeas corpus indefinitely, forever, extend the emergency forever, or he's not saying I can do it as president alone. And I don't care what Congress says, even if they oppose me, I will continue doing this.
Well,
it's that argument. You
know, Jeff, at times he does make that argument, and I wrestled with this, but it's always in a hypothetical context. Okay, you know, he gives the argument in the letter. He often uses the metaphor that a leg has to be sacrificed to save the body. Okay, and that really is a metaphor justifying extra constitutional measures, that you save the Constitution through measures that are beyond it. However, most of the time, he makes the argument more squarely on constitutional grounds. But there are these speculations, there are these rhetorical moments where he, just like he says here, you know, if a law had to be broken, it's better that one law had to be broken, and I would still be justified. But no law was broken. Again, so he uses this hypothetical language. Lincoln's quite shrewd. And he does it, I think he does it to convey to critics the magnitude of the situation, and also to, confer authority to him, to himself, to justify this very broad use of power. And he did exercise power very broadly.
So one of the ways in which Lincoln is sort of rebuked by the Supreme Court is in this case of Ex parte Milligan.
Yes.
They don't say that he was wrong or unconstitutional to suspend the writ of habeas corpus. but they do say he was wrong and didn't have the constitutional power to establish military commissions to try civilians accused of disloyalty. And as you said, this is a case about one person, but you said there were 13,000 Americans who were tried by these commissions. So this happened a lot during the Civil War.
Yeah, and mostly, it's important to note, it did. It happened mostly in the border states, right? The border slave states that were teetering on secession, where you had insurgencies. And it mostly had to do, and this is according to the great Mark Neely. I would recommend his book, The Fate of Liberty. Most of it was related to the draft and resistance to the draft to maintain an army, right? But not all of it. Not all of it. And there were, and there was the Union Army had censored the press, as Harold Holzer shows in his most recent work. That was problematic, needless to say, as well. The core ruling here is that military commissions cannot be used when civilian courts are still operating, and they were still operating in Indiana, where this occurred. So he should have been tried by a civilian court.
Now, what's interesting is we have two different opinions in this, and some folks have been asking about, what about martial law? Because in an emergency, we sometimes hear the term martial law, and it's been thrown out during different periods of American history. Now, let me just ask you this. In this opinion, all 9 justices agree that Lincoln, as president by himself, does not have the power to establish these military commissions, even if it's an emergency, because the constitutional protections to things like a right to a fair trial by a jury of your peers.
Like 4th, 5th, 6th Amendment,
as long as the courts are open. But then the concurrence by Chief Justice Chase says, but we think Congress could have authorized this. Congress could authorize military commissions for civilians. They just didn't happen to do that in this case. The president did it on his own. So the case is almost an argument about who has the power to do this, not whether there's such a power. Could you say a little bit more about this problem in emergencies? Could Congress declare martial law throughout the country and thereby suspend certain constitutional freedoms for Americans, like as in this case, a trial by jury?
Sure. Let's go back to your point about martial law. When habeas corpus is suspended, that means that someone can be detained indefinitely, right? And they are denied the grounds to contest their arrest. Judges are not given an opportunity to review the grounds of their arrest and release them if there are insufficient grounds. Now, once you've suspended the writ of habeas corpus, if you do seek to try someone, you can do so through military commissions, or one may do so through civil courts. Okay, and the ruling here, as you mentioned, is that military commissions have been reserved primarily for a theater of war, right? Under extreme circumstances in the theater of war. And so to use military commissions where civilian courts were operating was an egregious abuse of the Fifth and Sixth Amendments due process safeguards. The Chase argues, as you mentioned, that military commissions could be used by Congress. It could be established by Congress. And of course, this takes us up to current times. I mean, the military commission debate has been going on, right, for some time. That you had military commissions in the infamous case of ex parte Curran, where Nazi saboteurs were discovered in New York and Long Island. They were captured. They were tried summarily very quickly by military commissions and executed. And that's an extremely controversial precedent. And then we go to the Guantanamo debate, right? With the cases of Hamdi, Hamdam, and Boumediene. All of these cases involved military commissions, and the court actually, in the most recent of those cases, Boumediene, ruled that Congress must give due process to cannot simply use military commissions, but must give due process to the detainees in Guantanamo. And because it's not a theater of war. Now, if it was a theater of war, if it was a battlefield in Afghanistan, that would be a different circumstance. So this has been a highly contested issue right up until the 20th century.
So the principles of the constitutional rights of Americans are the same in war and peace. It's just who can exercise the power to modify those according to emergency circumstances, whether it's the president or Congress. And one question that I see someone.
Well, no, there's two distinct questions. One is you do not enjoy the full panoply of rights in a time of crisis. The Constitution allows, right, for the restriction of rights. The second question is an interbranch question. Who suspends the rights? The president, the Congress, the governors? Okay, so yeah, those are two different but related questions. Yeah.
Great point. Take us to that second question. Because another case that you had us look at was the well-known case of Youngstown Sheet and Tube versus Sawyer, which is about Harry Truman authorizing his Commerce Secretary, Charles Sawyer, to seize steel mills to prevent a steel worker strike, which would have stopped steel production. This is during the Korean War. And one of the folks is asking, they're saying, it looks a little bit like Harry Truman is acting like Abraham Lincoln here, that as the president, he is saying, I have the authority to act, to seize these mills, which sort of means take legal control of these mills and make them keep working, producing steel for our troops who are in Korea. And I'm just wondering, and they're wondering, have presidents like Truman look back to Lincoln's example of what actions are allowed or not allowed during a time of crisis? And I'm wondering, in this case, this Youngstown Sheet and Tube case, why did the Supreme Court say that Harry Truman couldn't take this action in a time of crisis?
Very good. One, because they didn't consider, even though we were fighting the war, they did not consider the United States per se a theater of war, right? Whereas, look, yes, of course, there are critics that say that Lincoln is responsible, for establishing the precedent of the imperial presidency. You can trace a straight line from Lincoln to Lyndon B. Johnson and Richard Nixon. I disagree with that, although I think we need to be also critical of some of Lincoln's actions at the same time, right? But this was an extraordinary circumstance, in some ways unprecedented, right? And if you look at the border states, I mean, the Civil War was the country itself was likely a theater of war. As opposed to fighting a foreign war. And that presents different circumstances. Also, there was an act of Congress, the Taft-Hartley Act, that had prevented the president from doing this. So he acted explicitly against Congress, whereas it wasn't so clear in the case of Lincoln's suspension of the writ of habeas corpus. There was still some precedent that the writ could be suspended in extraordinary circumstances. There's even a provision in the Constitution itself, right? Whereas seizing private property, right, it seems to be more, indefinitely, it seems to be more difficult, I would say, although not unprecedented. So I think part of it was he acted contrary to Congress, that there was no authorization for him to seize this. As I think some would say, even if you disagree with Lincoln, the Constitution does allow, there is a provision in the Constitution that allows for its suspension. There's no such Constitution that allows Harry Truman to take over a steel mill indefinitely, and he had acted contrary to Congress.
Well, that's interesting. At the last paragraph of the court opinion, and folks may have this out there, and the court makes a broad statement here about acting in emergencies. And they say, the founders of this nation entrusted the lawmaking power to the Congress alone in both good and bad times. So they've said, look, there is this power to take private property for public use. We call that the power of eminent domain. And the federal government does have that power, but the question is, who gets to exercise that power, right? And they say, look, that's a power to make laws. And
yes,
power rests with Congress. And then they go on to say, it would do no good to recall the historical events, the fears of power, and the hopes for freedom that lay behind their choice. Such a review but confirms our holding that this seizure order cannot stand. And one of the things it seems to me that they're implying is that in a time of emergency, it's really important that government exercise its power according to the rule of law, that we don't substitute emergency declarations or emergency actions like Harry Truman was taking for laws that are made by the legislative branch, especially if the legislative branch is available. And
it's functioning, right? It's available, it's functioning, it passed a law to the contrary. These are all important distinctions.
So it raises a question then, and some folks are asking, what do we see in this case or in Lincoln's example from presidential action about the problem of reconciling effective action in a time of emergency with the rule of law? Because that's one of the things that we Americans who have a constitution, we pride ourselves on the rule of law. And we're seeing today, of course, some governors issuing declarations that may or may not be supported by laws from their legislature. So could you talk a little bit more about, who has the constitutional authority to restrict civil liberties in times of emergency? Should we think it's usually going to be the legislatures because it's done through the rule of law?
Yeah. What's interesting is Justice Hugo Black, who writes this decision, also wrote the decision in Korematsu, the Japanese detainment case, and he upheld the egregious detainment of the Japanese. But part of his rationale, a big part of his rationale in that case, as you mentioned, was that not only did Roosevelt issue the Executive Order 9066, but Congress had approved the detainment of the Japanese. We forget that. I don't see it as, I see all branches as having to play an important role in striking that balance. Justice Black here denies inherent powers to the president. So he has a very strict view in this case of executive power that seems to depart from Korematsu. And I don't think the issue is clearly resolved. I think courts have an important function to review the actions of both branches. I think in extraordinary crises where the legislative branch is not functioning or is not called to session, that in my judgment, the president does have, or the governors do have the authorities. But, the question but that is temporary. That's temporary. Are these measures, if we're talking about today, are they going to be temporary? And to what extent should the legislatures be involved? And if they're not, are you circumventing the consent of the people? Is this going to, are the draconian measures going to be issued through the fiat of a governor and go on indefinitely without an opportunity for either the courts or the consent of the people through the representatives to have a voice? That's deeply concerning. I guess my personal view is that certain deference should be given in an extreme situation, but It should be deference in which our rights are jealously guarded, and that each branch plays a role in trying to strike that balance. It's not simply security. It's not simply freedom. It's ordered liberty, and that involves a prudential determination of the circumstances. The circumstances play a large role in all these opinions, but also I think each branch has a role, and we'll see if court cases, what the court rules in some of these on some of these measures. I would like to see the legislatures involved, and I'd like to see public discourse, and that's of course that's what we're doing here. Thank you. I'm proud to be part of this mission. It's an honor, that we simply have an opportunity to discuss, and without being accused as being treasonous or heartless, an opportunity to discuss some of these measures and even question them.
Can I comment on that last comment?
Yeah.
On the different branches have a role. All branches of government have a role. What about the different levels of government? We've been talking about the federal government a lot.
Yes.
What about the role of the states? Because another case that we have is a case called Jacobson versus Massachusetts. It involves a state directly, and it's a state that at the time of the turn of the 20th century, Massachusetts passed a law which allowed localities to require people to be vaccinated, especially against smallpox, which was a significant disease at the time and very rampant. And obviously now we have more like a public health emergency rather than a national security emergency. But I'm wondering if you could say a little bit more about, and in this case, the Supreme Court holds that a local government can force an unwilling person to be vaccinated against a disease like smallpox, so long as the vaccination does not cause them, it's not extremely cruel to them and cause them misery in the vaccination or put their life at risk. That governments can force us to do that, but that's a state government.
Yes.
Can you talk more about, in response to an emergency and restricting civil liberties, what the role of states are in this, and something that we're seeing playing out today?
Yes. There's no doubt, in my judgment, there's no doubt that the states have very broad power in regard to public health. Okay, and in regard to what's known as their police powers, historically, the power to regulate health, safety, morals, and general welfare. And it's interesting, in the court's ruling on equal protection and the First Amendment has chipped away at some of the states' authority to regulate morals. Okay. However, I think in regard to public safety questions, the states will have broad discretion, and I think the courts will be very reticent to question these measures. I'm not saying it can't happen, but I think that most of the law is going to be on the side of the states. Now, the question is, can the states do this? Can they impose these quarantine measures? In general, I think yes, they can. They have the authority to do it. But that second question, who does it? The governor or the state legislatures? We'll see. That remains to be seen. And can they do it indefinitely, right? How long does this go on for? They certainly cannot do it arbitrarily or unreasonably. Can they show that these measures are arbitrary? But I think the states are on legally have authority. And what we're seeing kind of is an interesting reassertion of federalism, right? Where the sides are switching. Democrats who have welcomed greater centralized authority are now defending the rights of states to use creative solutions to adapt to the circumstances rather than a one-size-fits-all solution. And we have kind of a similar situation in regard to recreational marijuana, where states have flouted the Controlled Substance Act, which is a federal law, and have gone it on their own. And Obama decided not to enforce that law. So there is this tension, like you said, not only within the federal government between the branches, but there is a tension among the federal and the state level. We just saw the other day how the battle President Trump had with some of the state governors, right, saying that I have what the president says is authoritative, and he has the right to impose a national rule in regard to the quarantine. And the state governors disagree with this. And you even find, interestingly enough, state governors on the West Coast and in the tri-state area are working together to try and come up with a plan to reopen. To that extent, I think it's good that you have the creativity of federalism to experiment with what's most effective in dealing with the discrete circumstances of the breakout. But of course, you might need federal control.
Of a very important point, which is the federal government has power to act across the country where the Constitution gives it power. So
interstate power.
The power to regulate interstate commerce.
Yes.
So it could take actions to forbid people from crossing state lines in commerce to prevent the spread of the disease. But that doesn't reach into people's homes, into their private actions, and when they go out and when they can go to the store and those sorts of actions. Those, as you said, are really left to the police powers of the states.
That's right.
That can directly regulate citizens in their private capacities.
And states are certainly varying, right? Michigan, I think, being amongst the most draconian, in some of these measures, and some of the measures that seem arbitrary. The other thing is the national government can intervene if there is a fundamental right that is encroached upon, because as we know, through the 14th Amendment's Liberty Clause, certain provisions of the Bill of Rights have been incorporated and applied to the states. So let's say someone is prohibited from attending religious services. They would have standing to sue. They could sue the state and have a federal court review that. Or their freedom of association, or let's say that individuals hypothetically want to protest the quarantine, and they gather together, they have a demonstration, and the state governor arrests them. They may argue that the First Amendment is incorporated through the 14th Amendment's Liberty Clause and as applied to the states, guarantees them the right to assembly, the right to religious exercise, and that the state governments are violating these rights. We'll see. It remains to be seen.
It's fascinating because it's one of those situations where, let's take a case like free exercise of religion and being able to go to church.
Yes.
Obviously a fundamental liberty.
We know there's a minister in Florida that's defied that, right? That's in the news. Yeah.
But it's interesting that in those cases, what the courts at least have held is, and some folks are wondering, can the state governments really do that? And what we know is, from at least looking at the courts in the past, they've said, if you're talking about a fundamental right like freedom of religion, that they apply what's called the strict scrutiny test, right? And they said, is there a compelling government reason to restrict this right?
Yeah, the burden is going to be on the state. Yeah.
A compelling government interest.
Yes.
Other thing that they say is, the second part of that test is, as a lot of teachers and our students know, is that government's action, if it restricts that right, has to be for a very good reason, but it also has to restrict that right. It's called
narrowly tailored,
in the least restrictive way possible in order to achieve that end. And I just wonder, over time, as the epidemic abates some, we hope that people will start being able to argue, look, yes, government has a compelling interest to regulate freedom of religion for the purposes of public health. Yes, but does that mean that government can ban religious worshiping, or could it, for example, just require social distancing at churches? In other words,
that's a great point. Wow, great point. Great point. And I love how you mentioned the compelling interest standard, which places the burden on the authority who's to restrict the fundamental right. So the scale of justice is tilted, right, in favor of the individual liberty. And also that even if there is a restriction, it has to be narrowly tailored, right? So yeah, we'll see. Are these restrictions narrowly tailored, or are they overly broad restrictions? How long will they go on? Right? It's it's concerning. I don't. I've never seen anything like this in my time. There's no easy answer, but I think it's important for us to raise questions. My concern also is that such measures, such extraordinary measures, may have been justified by Lincoln during the Civil War, or even during this crisis, to avoid unnecessary deaths. We don't want to see them to become a political football where they're recurrent, right? Where this becomes easier and easier to do, and authorities may claim more and more power. That's always a concern. You talk about the Constitution and the rule of law. Eternal vigilance is the price of liberty. And I think we need to be eternally vigilant.
Thank you. Our time is, I'm trying to imagine our time has passed already. This has been a fantastic conversation. I want to thank you, Joe, for that.
Thank you so much, Jeff. I miss everybody. I miss all our people
We
over
miss
there.
you too. Godspeed.
Yeah.
Folks, I just want to thank you again for joining us for this webinar. So many interesting issues are raised by this discussion of civil liberties and the importance of understanding the relationship between our constitutional freedoms and the needs of public safety and public health. I think it shows us the importance of thinking constitutionally.
That's right.
As American citizens, can't just leave it to the courts. We can't just leave it to our elected officials. It's our job as citizens
That's
and
right.
teachers to educate ourselves in the principles of our Constitution, to understand our constitutional freedoms. Sometimes my students will say to me, why do I have to know this? Well, because there are times like this where
right.
citizens have to understand their rights and their responsibilities so that we can have a vigorous, healthy public debate about the best way to act in times of crisis. So I hope we use this as an opportunity, this crisis, to get some historical perspective, as we've been able to do today, on this matter of civil liberties in times of emergency, and to renew our own thinking as Americans into the fundamental principles of our country and the fundamental principles of our Constitution. So this has been one moment to do that. As I said, time has passed so quickly, but we're delighted to have had this opportunity to do it with all of you. We're going to continue our series, as you all know, and let me just emphasize to folks that if you want to learn more about the Ashbrook Center, or you want to learn more about what Dr. Fornieri was talking about with these documents and times in history, let me suggest some web resources for you. Ashbrook.org is a wonderful site.
It's great.
Which talks about the Ashbrook Center and what we're up to. Let me also emphasize teachingamericanhistory.org, TAH.org, a resource for teachers and students, and frankly, homeschool parents, which many of us are now, including myself. It's a great resource. Primary historical documents, study questions, helpful lessons for educating young people in American history and government. So let me just encourage you all to look at that. It's TAH.org. Everything on there is free for your use as students, teachers, and citizens. This is our, as I said, our fourth webinar in the series. Next week, we'll be joined by Dr. Lauren Hall, who is Dr. Fornieri's colleague at Rochester Institute of Technology. She's going to be talking about the American family in times of crisis, healthcare, education, and the trade-offs of coming home. All of you who have children or grandchildren at home now out of school are facing this situation right now. As Lauren told me, when I said, what should I tell the folks this is going to be about? She said, maybe the alternative title could be, we're all homeschoolers now. Help! What has the American family, how has life in the American family changed in times of crisis in our history? How is that time of crisis affecting it today? And Dr. Hall is going to look at the question, will the American family and the centrality of home and family reemerge in some way as a result of this crisis? Will we see shifts in education? Will we see shifts in healthcare toward a more home and family centered approach? And what would be the positives of that? And what might some of the negatives be? So it's a great topic. It's very timely, and she's going to give us some wonderful historical perspective on that. And that's one of the things that we believe here at Ashbrook, that we can learn from the past, that we can get historical perspective on what's happening, that it can deepen our understanding of our situation, and it can renew our understanding of American principles and give us hope. You know, we see that when we look back at American history, we've gone through serious challenges before, as we're going through a very serious challenge now. But we see that the grit and ingenuity of the American people and a deep understanding of our founding principles and of our constitutional order can sustain us through these kind of crises. So, as always, I want you to stay healthy, stay hopeful, and stay connected with Ashbrook. We look forward to seeing you next week. Thank you.
Thanks again for joining us. You can find more information about our various webinar series at tah.org/programs/webinars, or from our homepage at the top of the screen. You go to Programs, scroll down to Webinars. You can also see information about upcoming programs like that Insights from History webinar that we have coming up on April 22nd from our blog. You go to our homepage, look at the top of the screen, and one of the links is blog. And there you'll see posts about upcoming programs like Jeff mentioned. Thanks so much.